Good morning, everyone. This is the Vermont House Committee on Commerce and Economic Development. It is Thursday, March 27th, 2025 at 9:03 in the morning. We're here to start our day with page 342. We have our legislative counsel, Rick Sagal, with us. Good morning, Rick.
Morning. How's everybody?
It's wonderful. How about you?
Great. Thank you for asking. So I have draft 2.2 of a proposed amendment. It currently just has Representative Marcot's name on it, but it'd be up to the committee to determine how you want to use, if you want to use this language. Do I need to go over, Mr. Chair, do I need to go over the
Yes,
current
please.
status of the bill? So currently it is on third reading. It's been waiting for third reading several days. If you remember on second reading, the report of the committee passed the House, and there was a proposed floor amendment from Rep. Harvey, who's in the room. That is still on the House calendar, and there was discussion about a substitute amendment from this committee to maybe implement some things from Rep. Harvey and maybe change some of the things that you did in your report. So with that said, I'm going to share draft 2.2 of this proposed bill that we've been talking about. And I'm going to skip, there's no changes to the findings, to the definitions. I'm going to go all the way down to subsection B, which is the notice. And only slight changes here. May remember that the notice is in a form previously created by the Secretary of State. Because of other changes that this bill includes, this has been changed to the Attorney General. So the AG now would produce this form on their website, right? That you would print out or you would use as a PDF to fill in the details to send as the notice to the data broker. Subdivision B is not new, so I can unhighlight that. That still remains the same, that the notice has a disclosure, right, that says there may be some complications you are not intending by doing this. Okay, subsection C has been changed. So now we have kind of two major sections when it comes to penalties for violations. So the first section is that there is a AG enforcement. So subdivision A data broker that receives notice from a covered person, that notice that you get from the AG, that discloses or rediscloses that information more than 15 days after receiving that notice. So remember, they get 15 days, right, to comply. So if they don't comply within that 15 days, they are assessed a civil penalty of not more than $10,000 for each violation. This is a fine, right? B, the AG, which would issue this fine and enforce the fine, has the same authority to adopt rules to implement the provisions of this section and to conduct civil investigations. This is the standard language that the AG gets when it comes to their ability to enforce laws that we pass. So when it comes to rulemaking, understand that this would be giving the AG some latitude to develop how this works, the framework for this. If you're not too familiar with rulemaking, they would come up, develop proposed rules, and they would come to the General Assembly. We have a committee that reviews the rules presented by various agencies, and the legislature would be able to have their feedback on if this rule is legitimate, if it kind of fits in line with what the statute is. Just want you all to know that you're giving the AG some latitude here on how they can enforce this section, this statute. Are there any questions about this language? All right, maybe once I get through everything, we can have a discussion. Private action, so subject to requirements, which I'll get to in a second.
So, just to refresh your memory, chapter 63, subsection 1 is consumer crime.
Consumer protection, correct.
Right.
Now, this is not necessarily the deceptive stuff.
Yeah,
It's a specific statute. This is just giving the AG the authority to enforce, make rules pursuant to that chapter.
Yeah, thanks.
And the language is all laid out there on what they can do.
Does 63 subchapter 1 provide the AG with any authority that supersedes any other language of their activities that may exist in the bill?
No, I mean, the statute gives the authority that the AG can use to, I think the major thing is rulemaking, right? So when you give the AG rulemaking, they can develop things in line with the statute. They can't go against the statute, but they can create a rule that allows them to use the statute in a way they think makes sense practically. That we don't have time to type out every single direction. You want to give the agency some latitude. So that's what rulemaking does. Does it give the AG additional powers? I can't say no to that, but it's not this kind of wide swath of just here, do everything that you think is for the best. That's not true. Yeah.
Okay.
And you have Todd Delos here who might be able to answer, specific AG questions. So private action. So again, subject to the requirements I'll get to in a second. Same thing. If a data broker continues to disclose 15 days after notice, same language as the fine. Okay, so you have two paths. You have the AG path where they can issue a fine, enforce it, or you have the private path where a person who has their information still out there, they can sue the data broker. And this is the language that came out of the report initially of the committee. You may recognize this. It hasn't changed. Damages, either actual or $1,000 per violation, whichever is greater. Punitive upon proof of willful or reckless disregard. Reasonable attorney's fees and other costs, or any other equitable relief like an injunction. So B is the safe harbor, and this hasn't changed. If a data broker gets sued, right, by a cover person, and they get served with the process, if the data broker then follows the notice and removes the information of the covered person within 15 days of being served, the data broker is only liable for attorney's fees and court costs. There's no actual damages. There's no liquidated damages, just those two reasonable attorney's fees and court costs. So that was in there last time. This is still in here. It's the safe harbor. However, subsection I, or subdivision I, they don't get that safe harbor if after receiving notice, that initial notice, they retaliate against the covered person by disclosing additional information that they hadn't disclosed before, or if they redisclose information at any time after having received notice. I've tried to make this, I'm very aware of how this can be confusing. And a lot of it is because the word covered person, phrase covered person, is used throughout authorized agent. This is, to me, the cleanest way to do this. If this is what you want, this is the cleanest way to do this, but it's still going to take a little bit of time for a person to understand what their rights are. It's easy to say you have the right to sue if the data broker does not comply, or the AG has the right to enforce the violation if the AG chooses to do that, or both can happen. I also want to make that clear. You have two paths.
I have a couple questions. One thing I'd like to put in, I have a couple of other questions. First of all, I would really like in the top, we hadn't really discussed this before about letting people know that there is, that this could impact their ability to do business transactions.
It's this here, right? Subdivision B.
I would like added to that.
Okay.
That they need to understand that this does not necessarily remove their name from all databases, and that those databases may still, though their personal information may still be accessible through publicly accessible databases, such as a grand list or tax rolls or something like that. I do not want these people lulled into a false sense of security.
What do you think?
Second thing is, I see no language in here requiring a protected person to offer proof. What is to stop me from saying, hey, I'm a protected person. I want you to remove my name. And I have a third question, which I'll wait until we hear from the Attorney General.
So there's specific language, right, that says that the notice cannot require that you prove who you say you are, right? So yes, a person could technically submit a notice saying that I am John Smith and I want my information removed. And if the data broker does not remove it, or cease disclosing it, then that John Smith person would be able to sue, but that is where it would get complicated for that person who's impersonating, right? Because the court would, I think, hesitate. They'd say, well, are you not that person? So at that point, something would have to happen. They'd have to be notified that you're not, why do you care about this? You've not been harmed. This is not you, right? So I don't know if the committee wants to talk about ways to address that, but
what I want to say is, when we require verification of a person, we're sharing more data, right? We're putting data out there. And so this is the, how do you walk that fine line, right? Where you have somebody who's saying, stop sharing my information. If it is that person, they are the only one who will be able to file suit, right? So what is the harm in somebody saying, stop sharing my information for this very limited group of people? The data broker, there's no penalty for them. There's not, right? There's no penalty for them if it's not a person in one of these covered classes.
Yeah, I mean, if it's implied in the lawsuit that at some point during the that will come to surface and proof will need to be provided, I'm okay with that.
Yes.
And I also think that covered people aren't, most of them, if not all, have the time or the wherewithal to try to track down all the data brokers that need to be notified. That are out there providing this service need to know who their customers are and should know that they are a covered person when they sign the agreement with them, right?
Or if they take the next step to file on behalf
Well,
of
yeah,
that person,
they're gonna need-
they're gonna be subject to some penalties by the court if they're misrepresenting the court.
Right. Yeah.
This is a silly question. Well, this is the question I have. What is a civil penalty?
it's like a fine.
It's a
That's
fine.
that's not enforceable with prison time or any type of criminal implications.
Okay. Is there a reason we don't say the word fine?
You can call it a fine.
Okay.
Yeah. I use it as if that's a better,
I don't know.
Are there other forms of civil penalty that would be, that this law would be, looking at,
other forms of civil penalty.
other than a fine?
I mean, that's kind of the reason to sue somebody is usually to get compensation, right, for your harm. So the injunction is another remedy for like a civil penalty. But that's, yeah, it's mostly monetary.
Fine. I think I would say if. Civil penalty means-
What is a standard convention? Language.
Or this type of thing. I mean, in Title IX, we call it a civil penalty, typically, you know. And in the judicial section, if there's a crime you commit, sometimes it's called a fine. That's probably more in that area of law is, you do this thing that's also criminal. There's sometimes civil and criminal aspects to something. So you call it a fine or you call it a misdemeanor, whatever, felony.
This is very clearly, the term civil penalty then is very clearly not in the realm of criminality.
Right, yes.
So if I understand, first 15 days, they don't remove it. Then that goes into the next stage, which is we can either go with a civil penalty, or they could, by going to the Attorney General, or they could do a private right of action.
Right.
So, and within that private right of action is that, you know, the calculated damage is not greater than $1,000. Or the greater of whether 1,000 or above, whatever. So we've got that private right of action in there. And then of course we've got, that's not really the case if they remove it within 15 days after the initial 15 days.
So you would have sued them, but you would have only been able to recover your attorney's fees and court costs.
Right. But after the 15 days, the total of 30 days.
Right.
That's when the fees are
Right.
assessed,
That's correct.
or the additional.
And by the way, you still, if either route you go, Attorney General, private, there's still a court involved, and there's still negligence, and you still got to prove that the data broker did this thing. So the data broker can obviously argue that they are in compliance, and whatever their argument is. So it's not a guarantee that you'll get $1,000 or that they'll be fined up to 10,000, right? It may not be 10,000. It may be 9,999. They can determine what they want to.
You have to go through the court process for the civil penalty?
Yes. Oh, no. Well, yeah, the AG's got to enforce the.
You can either pay it
Right, okay.
Yeah.
or you.
Okay.
They're likely going to challenge it, right? They're going to say, no, we're in compliance, and then the AG will have to enforce it, and yeah.
So in terms of assessment, it's sort of an assessment by operation of law kind of thing. As opposed to some during that first 15-day period or something. Who actually assesses that and where do they put it? Where do they send the money to? Like,
The civil penalty.
yeah.
I mean, I would defer to the AG's office how they handle the fine. They would collect the fine.
I see.
Yes.
Okay.
And then there was talk about starting the fund and, having that money go to some or directing, you can in statute direct where the money goes.
Yeah, yeah.
We have not done that here. But that's something you can choose to do if you want.
Like we're like struggling to make sure that the private right of action stays in there. And I know that for me, that was like one of the issues that I've had from the beginning. But that's all I want to say about that.
I would say for me, we're struggling to make sure that people have the right to seek. Yeah, I guess we have heard from the AG that they don't represent individuals. They only will do class actions if and when it makes sense to do so. That potentially leaves a lot of people out being able to have a way to protect themselves. So that's what I see this as.
I'm kind of concerned because we've done a lot of work on this, but we also haven't heard from the field. And we haven't heard about like the actual like lived risks that people are going through. And I worry that, well, I think it's certainly important that we protect business, protect the flow of business and all of that. A lot of this is about the potential of somebody getting to a very dangerous, very escalating place for them or their family. And I feel like I would like to hear from the field.
Fortunately, we don't have that. This is coming out today.
So I have 5 minutes. Let me finish, if you don't mind. There's just a couple things I want to hit before I leave. But this was added last time. So it shouldn't be highlighted, but just to make sure we kept it in, the limitations for the disclosure is made with the express or standing authorization of the covered person, so if you at some point gave authorization to do something, to run a check or to check your information that would be deemed consensual and not a disclosure. The form of notice, again, the AG would produce that notice and not the Secretary of State. Same language that they have 90 days from July 1st, 2025. The study from the AOA and ADS would be in here as well. No changes there. And I did add back the delayed start for private action, which is that now it's 2448C2, which is where you have that second path, right? So this data here is to give data brokers time to comply with this new law. So January 1st, the AG can start July 1st enforcing, but the private action would begin January 1st, 2026. You can still send notices on July 1st to data brokers, but you cannot sue them until January 1st.
What about the after the first 15 days? Are they still able to recapture their attorney fees and court costs?
So you're saying that someone sends a notice in July to data broker and they,
After 15 days, they still haven't taken it down.
right? So you wouldn't be able to file suit until January 1st.
Right.
And then
But
at
what if-
that time, they have 15 days. So let's say you file suit on New Year's Day, even though you probably can't. It's a holiday, but January 15th, if they have not stopped disclosing, then they would they would not be able to be in that safe harbor. They'd be gone and they'd be liable for damages, liquidated damages,
Right, but during that safe harbor time,
right?
there's still the penalty, there's still the attorney fees and.
Yes. Yes.
Are they
Yes.
eligible July 1 to get those, or do they have to wait till January?
The safe harbor would begin January 1st for this because there's been no lawsuit filed. So if they
That's
can,
fine, but
Yeah.
still the question is, July 1, are they eligible to, if someone misses their deadline, doesn't remove it,
a data broker,
and then subsequently removes it, do they have to wait till January 1 to be able to recover their attorney fees and court costs that they've
the covered person.
yes.
But
Because we get two different things
Right,
going on.
right, I
So
understand.
If after the 15 days, then, and if they file,
in January, they can't
They
file
can't
before
file.
January.
so I think.
I may change remedies to the action, the action provided to a covered person. That way they would not be able to.
Because what I see the potential here is that. We need to talk with the AG's office, but. What I am imagining is that when a covered person files with a data broker that they want their name redacted, whatever, I think we need to add some specifics to that too, that their name, address, telephone, primary, that I think we need that in there to tell the AG this is the minimum. They can read, and people can redact more than that.
Mhm.
I think we want it here so it's spelled out. I think there should be, the covered person should be notifying the AG at the same time by maybe filing that same form that they filed with the data broker, so the AG knows. And I think that if the AG starts seeing these pile up, they're gonna know that there's an issue going on. But they won't know if there's an issue until after the 15 days. And if we somehow there should be a notification at some point by the covered person, maybe it's after the 15 days that they notify the AG. file this form with them.
So another form, a second form. One with the one that you noticed.
No form and just file it with them, with some box on there that, you know, this was filed on X amount, X date and nothing has happened yet. Just thinking about that and then, at that point, the AG starts getting a lot of these notices and says, we got a problem.
Okay, so the cover person sends a notice to data broker. 15 days pass, then they submit a notice with the AG that the data broker's not complied. And they give, what do they give the AG? Their name, the data broker name? Okay. And then the cover person can do whatever they want. They can sue, they cannot sue.
But
the AG can do whatever they
right
want.
now, they can't do anything until January 1.
Right.
The Attorney General can.
Right. So would you want that copying the AG just until January 1, or you want it to be ongoing? That
I
they
think it
would,
should be ongoing. The AG knows if there are problems cropping up. I think. I think if these problems are cropping up in July, the AG does something, I think the word's gonna get out that we better comply.
Yeah, I like that idea both in the period before January as well as ongoing, because I think any mechanism we have to sort of, we got two remedies here and, you know, the AG has some responsibility, but if they don't know, you know, what's going on, I think that's very.
We also need to talk with the AG too.
I gotta run here. I can take maybe one or two.
It's not, I'm looking here, 15 days versus 10 business days. I think it's probably best to revert back to 10 business days versus 15 days after notice. It makes a huge difference in the world of business because if there's, you know, if you file it December 23rd, you know, that's two days minimum that within a week that are not business days. And it just cuts down on the time.
Business days with 14 days.
Right, but if the problem is if there's like vacation time, not vacation, but like when you've got 15 business days versus 10 business days, it's almost the same thing when it comes to the business side of things until you get into the holiday season, which is when I think Atlas sued down in New Jersey, correct? Am I correct on that? I think that's when they sued. It was in December. Maybe not.
You're gonna run into that with the 10 days anyway?
No, because it's business days. The Christmas wouldn't be considered a business day.
On the off chance we happen to have a couple of weeks where there's 2 holidays,
Yeah.
it would be an issue.
I just want to say the math didn't check out on the holiday piece if you go back and look at the lawsuits.
Okay.
Like I said, but I think business days, correct me if I'm wrong, is a defined term in terms of weekends, you know, excludes weekends and official holidays.
State holidays, right?
Right.
So that. So it might incorporate, it would incorporate weekends and official holidays. So you might be thinking about business days in a different sense, maybe, I don't know.
Monday through Friday is the standard, except for holidays.
Yeah.
Yeah, you're right, it's probably not defined.
And I think I also suggested, let's just go back to days. It's easier for people to understand, you know, business days versus, because yeah, Herb is right. It is state holidays, but we can discuss going to 10. I think it makes things a little bit more confusing for the public servants. But there's a couple times a year where it would may benefit.
There legislation to go to 32-hour work week.
I don't know. Not my portfolio, thankfully.
I'm on a tangent.
So so two things. Rev. Nicholas's idea about the disclaimer, including that your information may still be out there. Is that something you want me to add in the statute? Part of the disclaimer?
What are we
We
doing?
want to make sure people understand that there are other areas, there are other places where they're available.
And then this copying the AG on the notice after 15 days. Okay. Anything else before I'm sure you guys will have a few ideas after I leave. Yeah. All right, I'll come back whenever I'm. All right, thank you.
Secretary Riley, do you have to go or?
Don't call me when you're. Secretary.
Secretary? You want to go in? Sure, that's fine.
Yes.
Yeah. There's an extra chair up there.
Good morning. For the record, Denise Riley Hughes. I'm the Secretary for the Agency of Digital Services, also the state's Chief Information Officer.
And for the record, Josiah Raish, I'm the state's Chief Data and AI Officer.
Welcome.
Thank you, and thank you for having us here. I will admit we just got the invitation for this, and I have not had an ample amount of time to go through the deeper mechanics of this. And so at the pleasure of the chair, the co-chair, and the committee, I would welcome a stage setting opportunity for you to ask what you would like to make sure that we cover.
I think your area in here is towards the last section. It's a study that it's been in the amendment that was brought to us by Representative Harvey that talked about including state government, municipal government in as part of this bill. And I think that without understanding what it means for state government and municipal government, if we would implement this, I think it's better we find out first and then implement it if we so choose. But I think we need to know what the ramifications are, what areas can't be redacted, or what agencies and what information is there that either state or municipal government can't redact. And then we have to talk about what kind of penalties there could be out there for municipal or state government for not redacting, all of that.
Perfect. Thank you.
So it's just right now a study with AOA and they consulting with you. I think they're going to have to consult with all of state government, and we've got the league involved in the Clerks Association and Treasurers Association.
Perfect. Excellent. Thank you. That allows me to put some guardrails into the conversation that we were planning to have. I do want to share that this is something that this being the confidential and personal information of public servants, has been a conversation that we've been having actively. One, we have a data privacy director that sits under our Division of Data and AI. I believe he was the first individual in state government under the executive branch that was certified in data privacy, which is great. So we've been focusing a lot around what records we are retaining, what records we're holding, looking at it from a personnel standpoint, because we're undergoing an ERP project. How do we preserve and restrict information? How do we store it? How do we comply with law? And there was a recent situation that occurred where we publish a phone book. That phone book has existed for 20 years.
Yeah.
So how we use phone books 20 years ago versus how we use it now is so vastly different. And when you looked at what numbers were on there, those were folks from across state government, and some of them were their cell phones. We're not sure who was populating it, but it sounds like it was many, many people. But I'm not sure they knew that it was being populated on a public-facing website. So we had a situation where an individual from the public did get a hold of somebody's phone number, and called them and wanted to know adamantly where they worked. So nothing to do with personal, but it was not an individual who would traditionally speak to a member of the public. So we had an opportunity to take that phone book down, working with the agency administration, and restrict the availability of phone number to office numbers only, not cell phones, and also managers, directors, and above, so that it created a little bit of focus around the department, the team or division that folks would need to call. And if there was an escalation point, that there would be supervisors available. But for cellular devices, those could be the same devices that folks were using for their second factor of authentication when they're logging into their machine. So we have a lot of processes internally here that need to change and modernize and adapt to personal information, both work personal information, as well as we're a very small state outside of that too. So if you want to share something that I may have not included in that depiction, because your team worked actively on that and quickly. Okay. We have some work to do. And so when I look at the study from a timing perspective happens after this law goes into effect. And so there's a missed opportunity here. I see it's December.
It's a study on something that could be in law later. It doesn't cover anything that's in
You're
law.
not, yeah,
Okay.
it's not covered yet. We're doing the study first.
To just
Before
to
we
understand.
add,
How do I miss that?
before we add state and local governments.
Was that confusing? Okay.
The state and local government is not included in the current bill. And so this is to understand how, going forward, could we possibly include state and local government in protecting the data on these folks? So this is
So there's a-
in the right order.
It's a two-part to the bill.
Yeah.
Okay.
So that's the bill. In the amendment, the Harvey Amendment, it does include, it's a strikeout, so it does include public, it includes government too. What we're saying is we're going to put another amendment in that would take that out and substitute it with the study. So we better understand before we implement.
I think that makes a lot of sense. I think one piece that we have been talking about is currently the law targets data brokers, and I think that's a thing. But the data brokers are getting that information largely from stuff that we're putting out online, land records, stuff like that. We have models for protecting people within state government from those public records, like Save a Home being one. But those are kind of mechanically very challenging, is the feedback that my team has received on those. Because, for example, for land records, oftentimes people end up having to establish a trust that isn't related to their name in order to actually like scrub their information from that. So I think there's work to be done there to make this so that it's actually achievable by a normal person. It's very challenging to actually accomplish, I think, what this bill is trying to do. One other thing that we've been talking about is the mechanics of removing your personal information from lots of data brokers, hundreds, is hard. And so that's another just challenge that I think our public servants would face as.
And if it's okay. So there's a study out there that says there's about 1,711 data brokers at the time of the study, likely more. Privacyrights.org says that there's 540. That was a 2024 number. We have at last look, and I was trying to pull it up on my phone, and it was actually not possible. We only have 426 registered in Vermont. So
I think we heard from the Secretary of State's office.
It's up.
Days ago it was 300.
So it's dropped. So that doesn't mean that only 300 and some odd have our data. It means that they're not registering, meaning that we don't have access to that. So the ability to the notion of the form and making it a little bit easier for folks that it really doesn't, because it is missing a major portion of the volume of brokers out there. And those are just US brokers. That's not non-US brokers either. So our concern pre-study is focusing it, limiting it on data brokers. Our focus really is around modernizing and updating internal policy and administrative policy that can bring us up to what the digital age is looking for. So we did a couple of examples internally, because it doesn't take an expert or a cyber criminal to go online and do a quick Google search on folks' names. And for the purpose of the committee and the testimony, I would never want to do that for an individual, because that's unethical. It's not right. But what we did find was just somebody in our conversation, maybe me, how easy it is to find information and build correlations it's irrelevant to a data broker. So what I believe the committee is looking to accomplish, regardless of a study or not a study, won't solve this problem, because the digital footprint that folks have just continues expanding and expanding. From a personal standpoint, the way that the bill is written, I would be considered one of those protected groups, and I can't share why. So I'm looking at this both from this could be me, how would I do this, as well as from a technical standpoint, from a data that we make available standpoint, from a restricted access and what we're implementing right now around confidential tags, restricted data tags. What brings us to great challenges is our public records laws have not adapted to this level of data or this level of requirement. It doesn't take into account some of this privacy and the advances of technology. And that would be where I would recommend that we focus on. I am an advocate for practice before policy, really, because the policy can dictate that practice, and the way in which this is applied at a restricted data broker perspective, this would create some major gaps and wouldn't actually accomplish a level of protection that we're looking for. And the study can show that, and we can wait for the study, but that from a technology standpoint, digital footprint, that becomes a real issue.
One option that we didn't get to talk to Sean about yet, so I'd be interested in his opinion on it
Deputy
too.
Secretary Brown.
Deputy Secretary Brown. Would be to include in the study a direction for AOA to put out a policy that covers this, and then let that policy cover most of it and come back with what are the additional gaps beyond that policy. So we could potentially cover the whole the executive branch of state government with policy, rather than having to do that in statute, and then identify where there's gaps at the local municipal level, which may allow us to be a little bit more adaptable to the continuing public records discussion and some of those other pieces.
So I appreciate that we're all trying to do the same thing. We're all trying to figure out ways to protect people's information when they're in positions, specifically at this moment, when they're in positions that could make them very vulnerable. And so what you said was the data brokers are collecting information from lots of locations, but then they're the ones who are making it easy to get for other people, right? And so what this bill would do, it would be going to that dispersion point and saying, stop dispersing that information. And so I 100% agree that we have to stop the information from getting to them as well, right? As easily, but I'm not sure that slowing down the information that the data brokers are making so readily available is a bad thing. And so I want to make sure that you're not testifying to say that it's a bad thing to stop the data brokers from getting quick, because it was a little bit muddied in.
No, cart before the horse maybe is more a perspective that I have on that is we have a numbers problem. We have a math problem when it comes to data brokers in the state of Vermont. And that is that the data brokers that do have the data aren't registered in the state of Vermont. So there is no inroad for the Secretary of State's form to be delivered for those users. And so those numbers and that problem is a problem in itself, but it's not the lifting off point of what we're trying to accomplish here. Even if, let's say that this were to happen and we've got 300 some odd registered data brokers, and this time last year it was 426 data brokers, what about the rest? And where's our enforcement, and where's the ability to consider those? The other piece is, what about the non-US data brokers? So that data, no matter what, is still going to exist. And we've not accomplished what this bill would have set out to do. If we force that first step being policy, internal personnel policy, that creates some alignment around staff restricted information at the onset, it then allows us to have a little bit deeper conversation around everything else. So then the data broker piece becomes everything else. But we don't need data brokers to pull information. I can pull information on everyone everywhere because the digital footprint is irrelevant to the data broker sales.
I think even without the data brokers in the mix, still, data's still all out there. And the mechanics of someone actually exercising a right under this to hundreds of data brokers seems like a challenge to us. That's not directly relevant to the questions you're asking about the study, but I think just wanted to share that as our perspective on that.
Yes.
I mean, I think part of this is trying to take a step, small steps in order to build like most legislation. It sounds like, so as far as the registration, data brokers don't have to be registered for them to get a notice. So it could be any of the 8,600 data brokers around the world. They can get the notices. They can have this action taken against them. So they don't have to be registered. It sounded like that might have been a confusion. But I mean, it sounds like, so one thing I would love to do that we talked about before, I know we went over the Data Broker Delete Act bill, and the definition of data broker does get more expansive in that. It sounds like you might be supportive of expanding the definition of data broker in order to catch more people. Is that accurate?
I would have to look at what you're proposing.
Just curious. Thank you.
Which I think this proposed bill call out specifically telling the data brokers they don't have to delete the data.
This one is not removal. This is basically marking as private, making it not public. At 211 is more of a Delete Act style for everyone, not just this. Yeah.
When we look at building some of the technical output of what these bills require, we try to look at unintended consequences. And so having the data, but telling and attesting to not sharing it still means that the data exists.
Sure.
And so you think about the breaches that are happening, it's not going to protect that data from breach, meaning that once it's out there again, it's out there. You don't need a data broker for that. Well, actually you did, because the data broker still had it. But we're taking their word that they're not sharing it. And so the unintended consequences, as you look through the mechanics around applicable use and how you would build the technology, it breaks down fast, and then it starts hitting the other areas around cyber. Nowhere in here are we touching criminal law, though. We're just touching civil. And typically, when I look at what we're describing as harm, the damage would potentially be done. So if the examples that are being used, if Daniel's Law is coming up as an example, suing somebody civilly or personally under a PRA doesn't, I shouldn't say that. I'm not a lawyer. Never mind. So I think that a comprehensive study around personnel policy and public sector staff policy around the information that we retain the information that we store and even sell aligns to the work that we're doing around the ERP project. It aligns to the work that we're doing around our data privacy and data and AI efforts. So I think it's a good first step, but I would want to make sure that that report is completed and done before any major action is taken.
Just out of curiosity, if somebody was working for the state and they wanted their information removed from state websites, would you guys accommodate that?
So it would depend on which state websites. So some things are public records where that's not, unless you're under one of the programs that allows you to be removed from a public record, like that's not something that we can do. There are other things though where, yeah, we could potentially, I think the phone book was an example. If you're at a certain level, like there is a good reason for your information to be available, not necessarily your home address, but at least your contact information. And so those we do keep public.
We're one of the few states that still has an active open database for every state employee's name, their job title, their pay, and all of those records readily accessible, easily accessible today. We're one of the few states that has that.
Most states you have to actually request it. Which, I mean, it's not a bad model. I mean, it's nice to be able to go online and to get information.
We're starting to get a number of public records requests from non-human entities. The public records laws in Vermont do not protect us from that.
Well, that sounds encouraging.
I know, right?
One thing, so I spend a lot of time with these databases, especially as a new legislator, trying to learn who I can talk to and how to get a hold of them. And something that I've noticed is that phone numbers are frequently not available. And I'm imagining that what that's showing or implying is the growing reliance of state government on people's personal cell phones for communication. If that is the case, that seems something that's happening to every business and every entity that employs anyone anywhere. That is, for someone who considers himself a good actor, I find that irksome, but I also get that that's the reality of where we are, and that it would become enormously costly to states to outfit everybody with a cell phone or some sort of work line. But which is indicating to me the slippery and sort of cloudy nature of the incommensurability between our public records expectations, our transparency expectations, and how it lives now, or what it's like now. I'd like to ask if your existing protocols, and I think I'd spoken with a select board member and former state legislator in Rutland County, who knew the score with that, with like getting personal information out of the way, but had to have a series of conversations with town clerks so that they were able to anticipate what that would be. How far away do you feel like that process is from moving quickly, even for people who are very knowledgeable about how to do it? And is that something that's a priority for streamlining or having be as responsive as perhaps people would anticipate it to be just for municipal employees?
Like getting contact information removed from things online?
Public voting records, things that have your address on it. Is it anywhere?
It's not an easy answer. Yeah.
Is it a graspable project to address? Is it something in your office, are you thinking about? Is that a priority? Are there a million things to do? And
I think it's an extended use case. We are working right now with municipalities around cybersecurity and cybersecurity standards and even digital equity, because every town has something different and they all have different varying degrees of access to those services. And out of the 247 towns, very few of them have the funding to be able to do what you're talking about, but also have technology in place that can allow them to manage at that level.
Can you mention extended use case? Do you mind explaining
what you're saying? So for the work that we're doing, we're we're trying to clean house here first. And
Okay.
so that's what I'm saying is that if we can do it great for our state services and for our internal processes here, we can give some guiding principles to extend out to municipalities. But it's tough to focus there first when our house is in need of order.
Starting with the bullseye, then going to the next ring.
So coming back to the study, it sounds like you're starting the work already.
We just didn't know it was a study.
But we would just like to get the information after you look at it, right? And is January of 26 a reasonable time frame to get information back, or would that be a preliminary?
I'm thinking we could get a good first swipe at it. I imagine there will be, like New Jersey has, right? They covered in their statute and their policy a bunch of stuff. And then they're like, and the Office of Policy or of Privacy there is working through all the stragglers, right? Because there are lots of small things that cover small populations that need to be cleaned up after. I think it would be a similar thing. We could get a good run at the main ones, and then there would be a bunch that we continue to find over time.
And is there something that we're missing that should be added in under our ABC, the extent of which public agencies would currently be able to accommodate these, fiscal impact, and whether additional staffing or training would be needed? Like, would you prefer it to be just that broad, or is there something else that we should be?
The main thing that I would include is where do we need legislative updates and where can we do it through policy? And that would be what I would consider for
Policy, yeah.
Yeah, because a lot of places,
Modifications necessary, yep.
yeah, a lot of places I think we could cover with AOA issuing a policy within state government. The local obviously wouldn't. So I think it could be get the policy issued and come back with, and here's all the things we think should be covered legislatively.
And if I could just maybe restate that or add more. The AG's office has been a great partner around identifying which statutes would apply. And I think that that's really critically important because although it may reside under one chapter, where those adjacencies are around our cyber breach policy, around public records requests, around definitions of state employees, state government, those are all pretty important because it's easy to manipulate and misinform something like this if we miss those. So I don't want to make extra work for Ade House by any means or the AG's office, but having them join aspects of the study would be really important.
Thank you.
Yeah, I want to make a comment about Daniel's Law because we reference it a lot in here. The Harvey Amendment is actually closer to Daniel's Law than what we are currently working on. Daniel's Law specifically, based on what I'm reading here, it is for government agencies, whether municipal or state. And the bill that the 342 has nothing to do with state except for the study. Now, I just want to point that out because we reference Daniel's Law a lot. That's not what this is. This is specifically a data broker thing, not Daniel's Law. And I feel like that's really important to know.
Daniel's Law had two pieces, right? It has a piece around data brokers and a piece around access to public information, I think. That's the way I understand it.
So I'm reading directly from danielslaw.nj.gov, and it says Daniel's Law was enacted in response to the tragic death of Daniel Andro. And it goes on, the law prohibits disclosure of residential addresses of certain persons on websites controlled by New Jersey state, county, and local government agencies.
I thought there was another, I mean, I agree, I think it does cover that, Mike.
With
I
respect
thought
to-
there was this other piece that dealt with data brokers as well.
Oh, okay, yeah, that seeking prohibition.
Can I have a question though, the witness? Is there a statutory framework for what are the roles and responsibilities of the data privacy director? Or is that?
It's not in statute, no.
It's not in statute.
Mhm.
Thanks.
I'm just wondering if you could.
You're correct.
Comment on, the whole thing of redacting things from the public record, which I think is great. What kind of, I'm thinking for future long-term planning, what kind of pitfalls are we going to, do you see any balancing that with the public's right to know?
I think, so let's not get too far ahead of ourselves right now, because that's part of what we would ask them to look at and come back to us with. I think it's premature right now to try to speculate on what that is without actually delving, because I think there's got to be a deep dive into law requirements and access and possible changes to the law in order for some things to be redacted. And I think what we need in this is also government operations be part of the receiving end of the study. So that they, because they're gonna have a lot of work to do around along with us. So I think if there's things that we're missing that should be in that study, if you could send them to us like yesterday, would be very helpful, so that we can get it right. And then maybe look at the timelines and maybe suggest a preliminary report time and then a final report time would be very helpful too.
You will work with Deputy Secretary Brown on that. And if you determine after today that you would like to include another working group in that, we'll work with them as well. But for right now, it sounds like it's two Agency of Administration and Digital Services. And we'll get that yesterday.
Yeah, and I think that it's more of AOA consulting with you, but then consulting with all the state government, but
Yes.
and then I think the LCT is part of that. I think that conversation needs to start, but as you said, we've got to clean our house up before we can recommend to our municipalities what they would need to do and kind of a better understanding of the costs and ramifications.
Yes. Yes. So for what the committee is asking, the Agency of Digital Services supports the concept of a study. We would not be in support of everything else that's written and recommended outside of that for now, because the study should show that, yeah.
Okay, it's the Representative Harvey amendment. So is there language for the study? Do we need more?
We'll provide that to you. And I will work on hopefully before end of day tomorrow. If that's equivalent to yesterday.
We were planning.
Today?
Planning on bringing this to the floor today.
And what time?
See, on the floor at 1 o'clock.
You're late, Deputy Secretary Brown. It's already decided. I'm kidding. Well, we will go right to work then, and let's target a 12 o'clock timeframe. Who would you like to be receiving that information?
If you could work with Rick Sagal, our
Okay.
legislative counsel, probably include our friend from the AG's office as well. That would be very helpful, because I think your suggestion was that the AG be named on that as well. And so if they're amenable to that, then actually include them as well. I think this is really an important part to this bill. It's getting, and I know you're already starting it, but I think we need, people out there to know that we're actually working on this.
Yes. And just as a last point, with the concept of covered persons, I think I kind of share to you just from a personal sense versus from a administration sense. State government its entirety, or I shouldn't say state government, public sector in its entirety does create equity among what that is. Because you think of teachers and you think of educators, that would be at a very similar risk to what has been described in prior testimony. And I think what the committee has been talking about. So it does extend beyond just the limitation of what is identified as covered persons today.
I think this is a start.
Thank you.
We're not named in it either, so.
It's real. Perfect.
It is. And I think, when you were talking about the phone book, I mean, years ago when we had phone books, your number was published in there, but you had the ability to choose for a private number where it wouldn't be published, right? So it's, yeah.
Right. Well, thank you very much.
Thank you. Thanks. Todd, do you wanna, or do you wanna, maybe Deputy Secretary Brown?
I just want to check with Pastor Schrader.
Okay, yeah.
Still.
Yeah, if they're waiting on you, go ahead and, we have time that we can.
I'm happy.
Good morning.
Good morning. Thank you.
Joining us this morning.
For the record, my name is Sean Brown. I'm Deputy Secretary of the Agency of Administration. And just for background, so the committee understands, when I was speaking today, I'll be speaking from experience of well over 30 years in state service, in public service. I first started with the state in 1991, and I've held quite a variety of roles in my career. And so some will be speaking from that background and some in my role as Deputy Secretary from the Agency of Administration. So start with, we were just made aware of the reporting requirement of this bill the other day. And so we've been a little shorthanded with a family leave in our office and some vacation. So I had limited time to really prepare, but I did spend some time yesterday and today. And I was working from draft 1.3, but I understand that there was a draft 2.2 maybe that came out today.
The study hasn't changed.
But it looked like the study hadn't changed from what I looked, but like the penalties may have changed a little bit and whatnot. And so with that background, one of my first concerns, and that didn't look like it changed, that there's not a definition of state public agency or agencies in the bill that's used within the study. And that could encompass a wide variety. I took it to mean state government and municipal governments, but that could be, there's political subdivisions like water commission, water districts and others, fire department, low fire districts that could be contained within there and subject to this bill. And so you could really construe it narrowly, or you could construe it expansively. And just given the severity of the penalties that are now in the bill, we would probably look at it very expansively just to make sure that no one got caught not being able to provide input into this bill or be subject to it without really understanding that. And with that in mind, what you're asking in this study would be a heavy, heavy lift for the Agency of Administration. Our central office consists of 5 people: the secretary, myself, a chief operating officer, chief communications officer, and an admin person. What being contemplated in this bill would be 2 years of a pretty significant lift of a study that we're just not resourced or have the capacity to take on in light of all the other reporting requirements that we have to do regarding the budget and spending that are the responsibility of AOA. We do have other departments, but they really wouldn't have the resources given what they need to do in terms of like the Department of Taxes, Human Resources, Finance and Management, Department of Libraries. That wouldn't be appropriate to pull their staff in to work on this. They wouldn't have the expertise. And a lot of their time is cost allocated to their funding sources. And so we would have to pull them out
And it would just, we wouldn't have the funding to pay for them, even if we could, if operationally we could.
Was you saying that? Well, AOA is the umbrella to all the other.
Over all the other departments.
And agencies.
Well, within the agency of administration.
We just heard that ADS is wanting to do this work. So should it be ADS?
Well, if I could step back, I have some other thoughts on the bill, and that might help inform the conversation a little bit in terms of looking at it. One, I would say, in our role, we kind of have a view into a lot of other areas of state government at the agency of administration. We kind of coordinate conflict within different agencies and rules and laws and try to find a path forward. So we have a lot of visibility, and we're not aware of any circumstance now where in our dual role of assisting covered persons in this bill, we really serve them in two ways. One, we have many who are our employees, like social workers, police officers, and whatnot. But then also as citizens, we engage in various state services, some voluntarily, some not so voluntarily, like we all pay taxes. We all have to, be licensed to operate a vehicle. We have to register our vehicles, and we obtain a lot of personal information as a result of that work. And most of that is already subject to very strict confidential and privacy laws across state government in terms of the way we collect and manage. And we can only release that data in very restrictive ways according to law. So we're already limited to what we can share by the laws of this state. And just for some background on that, we have the Public Records Act, which kind of, we want to be transparent, open, and full in terms of government and what we do and who we serve and how we do that work. But, in the general statement for the Public Records Act, there's language that says all people, however, have a right to privacy in their personal and economic pursuits, which ought to be protected unless specific information is needed to review the action of a government officer. So essentially saying as state employees, we do have personal lives and our personal information is personal to the extent it's unless it's necessary based on an action we took. And then the Public Records Act goes on to exempt specific records of our employees, and that they can only be disclosed unless specifically authorized by law. So one of the sets of those are our personnel files. So all the information we contain on our staff is confidential that we collect, like name, address, all of that. Just as a little anecdote, one of our staff recently moved. They also were expecting to have a baby. It came early. I wanted to send them a gift. I don't know their new address, and I'm not authorized to obtain that from HR, even as Deputy Secretary of the Agency of Administration, because it's not for an official use. So I can't send a gift or a card to this person's home. I could call them specifically, but I don't want to bother them for that information right now, given they're gelling as a new family. So even there, there's very strict rules in terms of, like, if I reached out to HR and said, I want to send a card to so-and-so, they'd be like, I'm sorry, we can't give that to you. And that's happened in the past. Also, within the public records sphere, there is a carve out in 3 VSA section 910 regarding employees that were required by law annually to send a list of all of employees in specific bargaining units to the union. And that includes their name, their address, their personal email address, their cell phone, and their home number. However, the law specifically says that it shall be kept confidential and it cannot be copied or shared with anyone else. And so that's a carve out where we do share that, because as the bargaining unit representative, they want to be able to reach out and offer their union services and see if someone wants to become a member. So again, a very narrowly tailored
exemption to that where we can share that. But that's one of the very few exceptions. And then other than when we share tax data, with the IRS on a W-4, a W-2, depending on, if it's a new hire or annually when we report someone's income and taxes withheld to the federal government. Again, with the DMV, information that we obtain in someone getting an operator's license or registering a car is protected under state law, but also protected under federal law. 18 United States Code, Chapter 123. Again, I would say the tax department's within our purview. Again, 32 VSEA specifically says that no present or former officer, employee, or agent of the Department of Taxes shall disclose any return information, which would include the person's name, address, date of birth, social security number. Again, take that very seriously and protect that information as well. So I'm not aware that and then also there's prohibitions against in the Public Records Act of us, selling or sharing information that's non-public or selling any public record for that matter. So we don't share information with data brokers now. The one area where I see a state employee could have their information put out publicly for someone to see. And I'll just use this instance, and I recognize, and I don't use it to be light in any way. As a former commissioner of the Department for Children and Families, the work of family service workers is very challenging, very demanding, and at times can be very dangerous. Many of those social workers that work for the Family Services Division are licensed social workers or licensed psychologists. That's a profession that is regulated by the Office of Professional Regulation, Secretary of State's office. So their name may show up if they are licensed in a database. And then if someone made a formal complaint against that they acted unprofessionally, there would be an investigation, which is kept private until there's a finding, and then that would be a public record as well. And then this law also looks at someone currently employed, but also someone formerly employed. And we have many professions that we employ that are covered under this bill that are regulated professions by the state of Vermont. Judges sometimes step down, continue to practice privately. That has happened. Psychologists that might be working with departmental health that are licensed, social workers. There are law enforcement officers might become, and work in another profession, and all licensed publicly and in the database. And I think would be very cumbersome for the state to try to have to track someone post-employment to see where they've gone and make sure we redact their information from any database. And then I think, that's not for me to say this, but is it fair that someone practicing in a regulated environment gets to keep their information public when the vast majority of the others are not? And I'll leave that to this committee and the legislature to decide. But my concern is you'd be putting the state of Vermont at great jeopardy in terms of with this bill, in terms of what you're working on right now. Just given the vast way that we, work with people, particularly licensed individuals who might leave our service and then go in the private sector. And then their information might become public in one of those databases because that's the work that licensing agency does. And then we could be subject to a $10,000 fine if that information. And I know that you heard from the Secretary of ADS that we do our darndest to protect, our information online and prevent data breaches. And that we take that role very seriously.
Two things going on. The bill itself doesn't require you to do anything. There's an amendment that if the amendment were to pass, would then require you to do a lot of things that we have really no clue about yet. Some of the issues that you just talked about. So that's why instead of putting the cart before the horse, we're wanting to understand what areas there are, what are the ramifications of state and local government having to comply with a request for redaction. So it's not an automatic redaction. It's if a covered person requests that you redact their information, that's when you have to do it. You don't, it's not automatic. So, so what we're trying to get at in the bill itself is a better understanding of that whole system. And what is it going to take? Maybe it's something we don't want to do because we don't right now have all of the underlying statutes that are out there that require public notification opposed to the ability to redact. So I think but we're trying to get that work done and better understand what the landscape looks like before we do anything.
No, and I appreciate that, Chair. I think from our perspective, we'd appreciate you keep the horse in the barn and not worry about whether the cart goes on before or after the horse. I think just based on what we know, we would be opposed to adding this to state government. I think that's what I'm trying to share with the committee at this point, that just given what we do now and what's protected statutorily, we feel like that provides ample protection for our employees and those that we serve and where we collect this information that you're covering under this bill.
Appreciate your testimony. A little confused though, because I hear you're saying there's really no need for a study because we have in law, provisions that protect that kind of information for at least state employees. But then we were also hearing some concern on the part of digital services that, there's some things that need to be done, and they're actively involved in trying to create additional protection. So I'm just a little confused about that. Why would they be doing that if there are existing laws that protect state employees from having others get their personal information? I'm a little confused.
I see them as two separate issues, really. One is, we're required by law to protect this information. Some of that's in paper form and some of that's digitally. What we're really talking about on this other area, and I'm not the Secretary of ADS, I wasn't here for her testimony, so I apologize. But really, that's just how we store and maintain and ensure in an ever increasing complex cyber world where our systems are under threat constantly. How do we protect that information? We take that very seriously, but this bill wouldn't change any of that. I guess what I'm saying is that work continues because we have an obligation to maintain its sensitivity now, whether it's a deliberate disclosure or a non-deliberate disclosure, like someone hacked into our system and stole that.
But not just some of the testimony we've heard is that data brokers will, maybe not intentional, or I guess testimony was that data brokers, a lot of the information, personal information that they receive and then disperse to other folks comes from, either municipalities or state agencies already. So, and again, I don't entirely understand why there's no need for some type of study around, because that would help, I would think, restrict the flow of personal information for these folks anyway, to the data brokers. I understand your concern about resources. That's an issue too. I would think it would be decent.
I would say data brokers are accessing legally available information on our systems right now. They're not accessing confidential information. So if they're able to identify all licensed psychologists and they want to target something to licensed psychologists, that's publicly available data right now on the Secretary of State's page. And the legislature's made a conscious decision that we want a license, and that information is available for the public to see in terms of when making a decision who they want to see or avail themselves of services. That's not something like we're publicly required to share that data and information. Same with a licensed attorney or a licensed doctor or a licensed social worker. The state of Vermont has made a decision, if you're going to engage in that practice, we're going to require that you be licensed, and that's publicly available. And then if you go through any disciplinary matter and and then there's rules around when that becomes public. So that's a public protection in itself, so that consumers can make informed decisions about who they avail themselves of services or not. And I guess one of the things I was concerned about is that you would be shielding under potentially this bill, if you did expand it to current or former certain covered persons like judges or social workers or psychologists who met the requirements of this, and they left state service, went into private practice. You would be, as a former employee, they could shield certain information under this bill if you expanded it. And that would be in conflict with the other public protections that you have put in place now, where you say that we want to license these individuals. The public ought to know they're a licensed individual, and they should know if they have any disciplinary history, so that when they're making a decision, that they can make an informed decision. And if this bill went in and applied to the covered persons, to former state employees or some others, depending in here, you could be putting the public at risk of not being able to make informed decisions who they engage for certain type of professional services, if people want to keep certain information confidential.
I don't quite, I still don't understand, but I'll stop.
I think you just articulated the reason why we need to study it.
With all due respect, I think, as you're passing legislation with this magnitude, I would think the committee would want to, work with, its inside resources to really study and understand this before they move a bill forward. I think that's our concern. That we certainly,
Maybe I'm not crystal clear. We are not attempting to put state government and municipal government into this bill right now. This is only for data brokers that are out there supplying the information. We do, however, think it's important that we get information back to understand if and how we can protect covered persons from their data on public websites, on state and municipal website. That's what we're looking for. So we're not even saying right now, no, we want them in this bill. They're not. We're just trying to get, we need a lay of the land of where there's conflicts in law. Should we be changing that or not? We need to understand the public good. So I think that's what we're trying to attempt here. Right?
I just, so the article that came out in Digger in 2019 of the 15 years of the state selling the DMV's data. I'm just curious, is that practice still going on or similar practices, or was that shut down after that went public?
I wasn't here 15 years ago. I know there are certain laws now on the books that prevent that. And so that's what I was referring to. Only the DMV can only be shared in very specific information now under state and federal law.
See how much we made.
Yeah, it does. I'll send you the article. Right.
That's terrifying.
Deputy Secretary. Thank you.
Thank you.
I just had a question. I guess from your point of view, the privacy laws that we currently have in place, are they up to date with the current landscape of our digital world and communications?
I would defer to the ADS secretary on that. I think in terms of what legal protections are there, we believe they're sufficient. I think in our ever-changing world, and this bill wouldn't address this, we're under constant cyber attack with people trying to hack into our systems. This bill really doesn't address that.
I think the point, my understanding of the point is to study all of these things and figure out what the mechanisms are. How we're gonna be able to protect ourselves, because after 20 years of work moving fast and breaking stuff,
Mhm.
the public and our governments are on the hook for cleaning this up. The federal government has not helped us. We are the ones that are responsible for figuring out how we protect ourselves and our information. And also, how do we give the public enough information for them to do what they need to do and to hold us accountable?
In terms of the data brokers.
I think in terms of data brokers, but also, you know, as government officials, you know, we do hold a lot of power, we hold a lot of information, so just to ensure that we are protecting people's information and we're not causing harm. So I think my point is that I think the study is important for us to do the work of updating and to do the work with ADS and possibly with you and with other agencies and our municipalities to make sure that our information is adequately like meeting the moment, especially as we head into an AI future.
Happy to answer any further questions from the committee in terms of if the committee is still wishing for a study to move forward. I mean, we certainly don't have the internal resources to do this study, but happy to further that conversation if this isn't something the committee is still looking to explore in a final. Thank you.
Thank you. Thank you. Let's take 10 minutes.